Good evening. My name is Mr. Laurent, Aurélien Laurent. With my colleague Ms. Urbanova, we'll be having a match for the Inter-University Law Debate Tournament, day 3, between two teams. So I give the floor to my colleague who will be hosting the match.
Thank you very much, and good evening and good day to everyone joining. Welcome to the two teams. Welcome also to one of the judges who will be joining us live for the session, and also good day to the two other judges who will be following either the live stream or the recording. Thank you, everyone. So for today's match, we welcome the team from King's College London and University of Antioquia, who is actually following up for the participation of their team prior year, which booked him a seed 1 for the allocation of teams in this group phase. The teams have prepared for the topic, the law of the flag principle may be the best approach for governing virtual spaces, providing a consistent legal framework for all stakeholders to navigate and abide by in online interactions. So the teams prepared for two sides of the argument. In a short while, we will know which team will defend which position. But before we do that, it's time to learn a little bit more about our participants, perhaps starting with University of Antioquia, Ms. Ordóñez.
Thank you very much, and hello to everyone. Thank you for joining us here today. My name is Melissa Ordóñez. I'm a law student from the University of Antioquia, and I wish you the best of luck for everyone.
Thank you, and welcome. Joining us from King's College, Ms. Ahmed.
Hi, I'm Aisha Emmer. I'm a second year law student and very excited to be here, and good luck to the participants.
Thank you and welcome. Joining us from Antioquia, Medellin, Ms. Vasquez.
Good morning. It's a pleasure to me to be here. I am Valeria Romero, and I wish the best success in this debate.
Thank you and welcome again. Passing the floor to London this time, Ms. Nematzadeh.
Hi, thank you. My name is Nusha Namadzadeh. I'm a law student at King's College London. It's very nice to meet everybody, and I'm looking forward to what I'm sure will be a very fruitful debate.
Thank you and welcome. Passing the floor to Medellin, Ms. Barbosa.
Hello to everyone. Thank you for being here. I am Michelle Barbosa. I am a law student from the University of Antioquia, and thank you.
Thank you very much. And also, if I can, I would like to pass the floor to one of our three judges, Mr. Kazi, if there's anything you wish to share with the students.
Hello, good evening, good morning, depending on where you are. I'm just very happy to be here, and good luck to all the participants. And I'm just excited to see what comes of this debate. So good luck to everyone.
Thank you. So if I can just ask for a confirmation, you can see the screen for the allocation of positions?
Yes.
Thank you. So as always, there are 4 options for the algorithm to choose from. All right, so for today's debate, it is King's College of London which will defend the position against. Thus, the position in favor will be defended by University of Antioquia's teams, arguing that the law of the flag principle may be the best approach for governing virtual spaces, providing a consistent legal framework for all stakeholders to navigate and abide by in online interactions, whereas it is the team of King's College London that will argue that it may not be the best approach. So you now have 5 minutes to finalize your preparation, and afterwards, team in favor will start. Thank you, everyone. This now marks the end of your final preparation for the debate. We'll be starting with the team in favor. University of Antioquia, you now have 4 minutes for your opening statement.
Thank you so much. May I confirm that I am audible and visible?
Yes,
Please.
you are.
Okay, thank you. As a team, we represent arguments based on international law in line with the given statement. The law of the block principle may be the best approach for governing virtual spaces, providing a consistent legal framework for all stakeholders to navigate and navigate by online interactions. To begin, I will present an important point about the importance of the sovereignty principle through the law of the block principle. My teammate Melissa will argue that states have international responsibility for their nationals' actions on the protection of human rights. Finally, my teammate Valeria will bring to the discussion the protection of individual rights in materia of cybercrime. Virtual spaces are inevitable and no nation can live without them, but in reality, they haven't been able to be regulated. They don't understand borders. However, what do we understand as virtual spaces? The United States Supreme Court affirms that it's something located in no particular geographical location, but available to anyone and anywhere in the world with access to the internet. Currently, the legal framework applies to virtual spaces and the internet is both national and international. In consequence, the Budapest Convention on Cybercrime, the Lanzarote Convention, and the Inter-American Strategy to Combat Treaties or to Cybersecurity were created to guarantee fundamental rights such as social well-being, freedom of expression, and public access to the internet. Our starting point is when the Permanent Court of Arbitration in the Palmas Island case established that sovereignty in the relations between states signifies independence of any other state, which clearly allows that the application of the law of the block principle guarantees the principle of sovereignty between states, since the competence, legality, and legitimacy of each state to judicialize its national servers are respected. The attempt to universalize the law has brought multiple jurisdiction conflicts because it is impossible to apply the same legal framework in different territories since the particularities of each state are unknown. Furthermore, this could constitute a dangerous justification for mass control systems of people. To continue with our argument, we found it necessary to make an analogy with the Permanent Court or International Justice in the Lotus case, who determined that international standards can be extended by interpretation to cyber operations not expressly contemplated. Therefore, for these virtual cases, the best approach to govern them may be the application of the law of the block principle, which breaks with universality and encourages the divergence of jurisdictions within virtual spaces. In this order of ideas, the United Nations Conventions on the Law of the Sea contains the rules on high seas. For that reason, the international spaces theory must be understood with the law of the block principle, which can determine the nationality of a ship, because at sea they are actually floating islands and their jurisdiction is territorial in nature. Therefore, there must be a territorialization of cyberspace, remembering the European Court of Justice in the Primini versus Ruches case, which confirms that the nationality of a server and a person who commits a cyber infraction becomes the forum that determines the competence of each state to impart justice, taking into account that they are floating islands of its territory and nationality. Thank you so much.
Thank you very much for your submission. Now we will hear the opening statement in the against position. You have 4 minutes.
Thank you very much. If you could just give me 1 second, I'm going to start my timer as well. Okay, thank you. The law of the flag is a centuries-old principle governing application of state jurisdiction to ships navigating the high seas. In short, it recognizes a vessel registered under and flying the flag of one state as an extension of that state, bound by the jurisdiction and party to the rights of that state. Decades ago, the necessity of such a principle was evidenced by the increased commerce and maritime travel that took place. In the modern context, there exists a similar but novel unbound domain being utilized on large scales for similar activities, that of the cyber web. While there exists growing consensus among states of regulating cyberspace to protect against harmful activity, we do not believe the law of the flag is the correct approach for the following reasons. The Internet lacks a single substantive physical entity to attach state sovereignty and a flag principle to. Unlike the law of the seas, whereby the flag is associated with the vessel, and it is the vessel to which the registration applies, in cyberspace there are far too many moving parts to be able to apply a flag without either expanding the policy to factors so far beyond the state's borders that it may lead to intrusion of sovereignty, and conversely, applying the policy to only activities that can be linked to a source within the border of the state is far too limited, given the breadth and capacity of cyberspace, and risks diminishing the utility of the policy altogether. For example, there exist questions of what parts of the web we would register within the state, who we would register with the state. What if an individual of one state uses the cyber infrastructure of a second state to attack a third? And what if we only limit the flag policy to activities carried out from within a state's borders? Can a citizen of state A then carry out an attack from a state B where their cyber policies are more relaxed? These are questions similar to current issues within the law of the flag in the context of state vessels. If they have not been resolved on the high seas, there's little hope of the policy finding solutions in the far more complex realm of cyberspace. Second, as an extension of the first problem, the application of the law of the flag would create a significant extraterritorial jurisdictional problem. The active personality principle of the extraterritorial jurisdiction, for example, allows a state extraterritorial jurisdiction over a citizen of its own that commits a crime overseas. But to whom would that citizen be linked if using the registered infrastructure of another state? Or how do we navigate the conflicts that would arise when a perpetrator can be linked to multiple different states at one time through the different parts of the web they use to navigate a single crime? This is in addition to the conflicts of extraterritorial jurisdiction that would undoubtedly arise, such as that between active personality and the protective principle, where a state claims jurisdiction over crimes carried out by non-nationals that threaten their sovereignty, security, or government, among other things. Third, inconsistency and or uncertainty. Unlike state vessels, which are one physical entity with physical features that shadow those of the states, the complexity of cyberspace and its continually changing environment, which is an uncontrollable ramification of technological development, makes it almost impossible to apply a flag policy without having to continually change it. This does not provide increased certainty, but rather uncertainty, as states and stakeholders will not know how to navigate these new laws. In sum, we need an international approach that applies to all countries equally, determines the boundaries of jurisdiction, and is able to account for the continual growth and development of cyberspace. One shape that this can take is in the form of an international treaty. Given the gravity of harm that cybercrime poses and the intersectional cross-cutting nature of web activities, states can be expected to manifest a practical and workable solution to the risks and threats imposed by the World Wide Web that doesn't simply cut and paste a solution meant for an entirely different subject matter, but establishes the long-term feasible legal boundaries that take into consideration the context within which those boundaries must function. Thank you very much.
Thank you for your submission. We have now heard the opening statements from both teams. Proceeding with the rebuttal, starting with the rebuttal in favor. You now have 2 minutes.
Before I start, may I confirm if I'm audible and visible?
Yes, you are.
Okay, thank you. So I will start. Thank you for the arguments presented, but we can observe that in the opening of our opposing team, there may be a generalization of the potential conflict with sovereignty. International agreements and clear jurisdiction boundaries established through international cooperation can ensure that national laws only apply to the citizens of a state or entities under its control. Also, applying the law of the flag principle, states could legitimately extend their jurisdiction to cyberspace, relying on the principles of active personality, also mentioned by Ms. Nusha, and national responsibility. Like ships on the high seas, individuals and entities carry an inherent nationality. Thus, customary law allows states to have jurisdiction to enforce their laws over their nationals, even for conduct outside their physical territory, under the active personality principle. In this way, the international responsibility of an actor is guaranteed given the bond between the individual and the state to exercise extraterritorial legal authority. Due to the problem of the lack of a clear physical territory for jurisdictional application in cyberspace, it becomes imperative to reinforce legal authority from a national link. A case that exemplifies this is the judgment of the Court of Justice of the European Union in Google Spain SL in 2014. The key here was that states can regulate the personal information of their citizens online, even if it's hosted on servers located in other countries, thus protecting their rights, such as privacy, legal security, digital forgetting, and others. There is also the Barcelona Traction case where the International Court of Justice recognized the international responsibility of a state for the actions of its nationals that cause harm to other states. So, responding to the concerns of the opposing team, by enforcing international law on citizens, even if they use foreign servers, states could safeguard rights and be held responsible globally for any infringement. Thank you very much.
Thank you very much. Now we will hear the first rebuttal in the against position. King's College of London, you have 2 minutes.
Thank you. Let me just set up my timer. Starting in 3, 2, 1. The law of the flag principle, as it applies to ships today, shows how this tracking of nationality of individuals will simply not work in the context of cyberspace. This is a problem that shipping law has been dealing with for many decades because of the ability that corporations and individuals have to move their nationalities and their citizenship from one state to another. Now, case law within shipping law has tried to rectify this issue by stating that ships can only register with one country or have one nationality at a time. But this is increasingly difficult in the context of individuals who may hold multiple nationalities / citizenships, but also corporations, especially tech companies who hold headquarters within several countries at one time, or move headquarters from one country to another to take advantage of various things such as access to labor, access to better resources, etc. Therefore, within the context of these countries, it becomes increasingly difficult for this nationality to be tracked. Even if we were to be able to track citizenships, which firstly raises questions of allowing individuals to have freedom of speech, etc., we would not be able to track the different corporations that are at helm of this technological development because they so often move jurisdictions for various economic benefits. Not only would, even if this were to produce the benefit of reducing cybercrime, it would bring increasing disadvantages in terms of the economic benefits and global development that comes from moving jurisdictions for corporations. For those reasons, the same law, the flag principle, cannot be applied to virtual spaces. Thank you.
Thank you very much. Now for the second rebuttal, starting with the team in favor. University of Antioquia debate team, you now have 2 minutes.
Thank you. First, may I confirm that I'm audible and visible, please?
Yes, you are.
Thank you. Thank you for presenting your arguments. Our colleagues from King's College has argued the possibilities of violation between states due to the lack of regulation in some places. But it must be said that precisely the application of the flag principle generates a coherent framework. Please take into the following approaches without a principle of competition. First, safe browsing. The United Nations has spoken of the need for control and digital security, protecting rights and non-discrimination. Second, the General Data Protection and the Budapest Convention make it clear that any information recorded on an electronic device must enjoy the right to security. And third, it provides a coherent and necessary legal framework. If we can have some principle that can give us competency during the COVID time, the United Nations report that, let me read it, email and text messages are not secure or confidential ways of communicating to someone the danger of being attacked. Also, in the case Lender versus Sweden, the European Court of Justice in 109 1987 established that a state is responsible to third parties that store data because it's an interference with the right to respect for private life guaranteed by the European Convention of Human Rights. One of the cases of digital privacy breach is when it was discovered in 2018 that Cambridge Analytica illegally accessed the Facebook profiles of 87 million users. Facebook decided to pay 725 million, but has not that been only that time that happened. In 2019, it agreed to pay 5 billion to settle a Federal Trade Commission investigation into its privacy practices. It also paid 100 million to settle claims by U.S. Securities and Exchange Commission. In summary, the scheme regulation allows ignoring liability with making of payments, while the law flags guarantees the principles of nullum crime sine lege. Any content constituting a crime must be clearly described by law. Thank you.
Thank you. Now for the second rebuttal in the against position, team of King's College London, you have 2 minutes.
We thank the opposing side for their wonderful arguments, but I think we must first emphasize that we do not stand against any regulation of cyberspace. We are simply saying that the flag policy is not the correct approach, and rather we are pursuing another international alternative that is specifically structured for the context of cyberweb. Now, I would like to bring the attention to the problem of registration, as the opposing team had rightly spoken of the need for regulation, but we contend that has not properly addressed registration and the risks that come with it. Now, there is a risk of manipulation of the registration process that would associate virtual infrastructure to a flag. Under the UN Convention on the Law of the Seas, states have complete control over their registration processes underlying application of a flag to a vessel. This allows for a specific problem known as flag of convenience and flag shopping, whereby companies divert activities to states with more relaxed measures to reduce operating costs. For example, Exxon estimated that it would cost 78% less to operate a 28-man tanker from the Philippines than one from the United States. We would face a similar issue, a similar flags of convenience and flag shopping issue within the cyber realm at a much larger scale, specifically because while it is stated that states enjoy sovereign authority with regard to the cyber infrastructure, persons, and cyber activities located within their territories, subject to international legal obligations, states can exploit, and there's nothing to stop them from exploiting and outsourcing their cyberspace activities, especially the criminal ones, to countries with weaker registration, hence taking the same problem of the law of the seas to the cyber realm, which is far more vast with far less borders and boundaries. Thank you very much.
Thank you. We have heard the rebuttals, we have heard the opening statement. It is now to hear conclusions. Starting with conclusion in favor, University of Antioquia, you have 2 minutes.
Thank you. May I confirm if I'm audible and visible?
You are.
Thank you. So the debate surrounding the application of the law of the flag principle in governing virtual spaces has highlighted the complexities of regulating cyberspace. While virtual spaces transcend physical borders and challenge traditional concepts of territoriality and sovereignty, the principle of the law of the flag offers a compelling approach to address these challenges by emphasizing the territorial jurisdiction of the states and the nationality of individuals and entities involved in online activities. This principle provides a consistent legal framework for navigating and abiding by law in cyberspace. Throughout the debate, it has become evident that virtual spaces are essential components of modern society. Yet the regulation remains a continuous issue. The existence of multiple legal frameworks, both national and international, has led to jurisdictional conflicts and legal uncertainty. However, the law of the flag principle offers a solution by allowing states to extend their jurisdiction to cyberspace based on the nationality of individuals and the location of servers, thus ensuring the protection of human rights and promoting accountability. Also, it's important to remember that the principle of the law of the flag is not a license for censorship. States have an obligation to respect human rights in the application of their laws, even in virtual spaces, based on, for example, the EUDHR. Moreover, the principle of the law of the flag aligns with established principles of international law, such as sovereignty and jurisdiction, and provides a current legal basis for addressing issues such as privacy, security, intellectual property rights, and cyberspace, protected in the GDPR, PCT, Budapest Convention on Cybercrime. So by embracing these principles, states can foster international cooperation, promote legal certainty, and uphold the rights of individuals in the digital age. Thank you very much for your attention.
Thank you. Now we'll hear the concluding statement in the against position. King's College London, you have 2 minutes.
Thank you. Starting in 3, 2, 1. A side proposition has pushed for a principle that relies on breaking from universality and enhancing the individual jurisdictions of each country in protecting cybercrime. However, the same problem that currently plagues international law regarding cybercrimes will soon affect the law of the flag principle under the situation, which is that countries, when dealing with cybercrimes that are of an inherently dangerous and sensitive nature, feel hesitant to share private information across borders for fear or further threat to their safety. Now, if we push for individuality and enhancing the jurisdictional laws, we are going to encounter the same problems, which is that countries will feel threatened and into sharing about the private breaches of data, because there is no universal treaty that is going to protect and safeguard their data and security. Furthermore, side proposition argue that this will not lead to problems of censorship and a breaking of human rights under the UDHR. However, a clear contradiction to this is the fact that currently measures of data protection such as the GDPR are not universally applied. Therefore, there is already existing discrepancies within how much these human rights and the freedom of information, freedom of speech on the internet are being protected, and how much data protection is being protected. This isn't just a problem for smaller countries with looser laws. Even the US and the EU have great discrepancies between data protection across borders, which creates hesitancy in sharing data across borders. Therefore, if we apply the law of the flag principle, it will only worsen concerns about data breaches being more common and more censorship taking place. Thank you.
Thank you. Thank you everyone for your submissions. You can now relax. You are no longer graded after this part of the session. We will do, as always, a little bit of feedback, a little bit of tete-a-tete on how you felt about the match, about the research, about the topic. So starting perhaps with the University of Antioquia. Ms. Vasquez, how did you find the topic and the debate?
And this topic was harder, I think, because like the girls from King's College had the same argument that we had in that position. So it was like so interesting debating, but also meet that principle of the law flag, it was new for me. So it was all on great experience and challenging us.
Thank you for sharing. Passing the floor to London, Ms. Nematzadeh, how did you find the topic and the debate?
Yeah, I mean, I was on a personal level when I was researching this, I realized, how much I am for the con side of things. So a lot of that was just very, very genuinely me. But in terms of the research, I would definitely think that aside from the fact that I would not apply flag policy to the cyber web, what it did make me realize, though, what it did kind of make me very much aware of also is I don't want to call it archaic, but a little bit of the outdated nature of the law of the flag in terms of the sea and the problems that it currently has, because, especially going into researching for the con side, looking into some of the problems that we're having with flags and companies, for example, it kind of brought a lot of international law into light, and how we sort of just carry on many, many doctrines and principles of international law that really need to kind of be readdressed and looked into within modern contexts that we're not doing. So it was an interesting subject, because aside from the cyber web, it did bring a lot to light of how we're approaching international law writ large.
Thank you for sharing. What about you, Ms. Ordonez? How did you find the debate, the topic? Is this perhaps something you were already familiar with?
First, thank you all very much for joining us in this experience. I am very excited right now. It was truly rewarding to engage in this debate, and I feel that I learned a great deal about cyberspace and maritime law. While I have encountered this topic in university before, it was only in a very general and cursory manner, mostly highlighting the issue of insufficient regulation on cyberspace. So it was exciting to learn more about this issue and enriching it through a debate. So thank you very much.
Thank you for sharing. Ms. Amer, how did you find the topic, the debate? Is there anything perhaps you were surprised to hear from the other side during the debate?
It was definitely new, because I think in the previous rounds, it's usually been one area of law that we've had to really focus on, but this time it was more delving into two and sort of combining them together. So cyberspace law and maritime law, which was very interesting. I think both of them were pretty new to me. I think about the sort of data protection / censorship side of the debate, I wasn't really expecting. But I mean, I think I knew sort of what the general concerns were, but I was pleasantly surprised to hear your rebuttals on it, and hear all the various bits of research you'd gone into, and I was like, I hadn't considered that for the pro side, actually. So that was very interesting.
Thank you for sharing. Same question to Ms. Barbosa. How did you find the debate? And was there perhaps something that you found surprising from the arguments of the other side?
Yes, I think that we all were surprised, because I feel that it was very funny, because we found very similar arguments, as my teammates mentioned it, and from them to ours. And taking into account that the principle is something that I haven't studied or even seen, for example. And that is why I feel like it was a kind of interesting, especially when we talk about it with our coaches.
Thank you for sharing. And now the floor to one of the most anticipated feedbacks perhaps you might be having for the students. Mr. Kazi, is there anything you can already share with the students now?
Thank you. I'd be more than happy to. First of all, I just want to say very well done. I think it was a very seasoned debate, and it was very nice to observe everyone's arguments. Also, given that, as you guys have mentioned, this was an area of law that you perhaps weren't particularly familiar with at the beginning, I think you guys did not really show that at all, and it was very, very good to see how well you argued. I did make a few points, which I think I can reveal here. First of all, I really appreciated the signposting by the team, especially when you point out to the audience, okay, my colleague will address this point, my colleague will then address this point. It makes it much, much clearer for the judges to sort of follow and understand the structure of your arguments. So well done with that. Something which I observed very, very well done with both teams was reliance on case law and actual legislation. I think that's always very good, as I'm sure you're aware. That really boosts the persuasiveness of your arguments if you can really refer to case law. One thing over there, though, that I will add is be careful with the names of the courts. So don't confuse the European Court of Justice and the European Court of Human Rights. Big difference. Otherwise, I think it was also good that you referred to customer international law, how customer international law imposes binding obligations, regardless of whether you have signed a treaty or convention or not. that was also very well done. Other than that, I think, yeah, another very good thing. I had some questions that sprung to mind, but when some of you guys said something, but then you were very quick to immediately resolve them, which is why I never really had to unmute myself to actually interrupt. And I think that would have also interrupted the flow of your statements. So that was more about the contents. Regarding presentation, I think all of you are good speakers. It was very good to listen to. One thing I would say, which it's funny because I used to get this feedback when I was a participant in this debate tournament, and now the tables are reversed. Something I really have come to understand the value of and appreciate the value of is speaking slowly and clearly. So, even if, let's say, you have 2 points you want to go through, just make sure, you emphasize where you need to emphasize, the intonation is very important. So, yeah, speaking slowly and clearly will, and even if, you just bring one argument, but it's very well spoken in the sense that, you take your pauses, I think it will come across much more persuasive than 3 arguments. I understand the time limits is also a bit of a constraint. Obviously, especially in the rebuttals, you only have, I think, 2 minutes. And there may be a lot of arguments you want to rebut. There may be something you've heard from the opposing side, which you're like, oh, I absolutely need to rebut them on this. But try and be selective with the arguments you pick. Try and pick the ones where you feel like you have the strongest chance of persuading the judge. And yeah. And then, just take your time with that and say, yeah, well, we will just raise 2 issues in rebuttal, and some signposting with the rebuttal is also definitely not a bad thing. So perhaps saying, okay, well, thank you for your arguments. In rebuttal, we'd like to just address 2 issues. And another thing I think which maybe could be enhanced a bit more is referring exactly to the arguments of the other side. So let's say if King's College London said something, the opposing side could say, well, our respected opponents or someone, they refer to this, this, this. However, our position is this, this, this. So, yeah. I think that's pretty much all I had. I hope this is somewhat helpful, but again, very well done. And it was very, very nice to listen. I didn't really have any other evening plans, but so this was actually a very, very nice end to my evening. So thank you very much.
Thank you very much. Thank you very much for joining and also for the feedback. Of course, thank you also to the other 2 judges who will be following us either right now live or will be watching at a later time. We will share these forms with you as soon as we can. Of course, the results and the matchups for the 8 finals, which will be actually the next round after the group phase has now ended, will be released during the mid-edition ceremony. So we will share, of course, the invites with you and the details. We just have to match the best time, as there are currently 14 time zones for the teams that are participating in the competition. So trying not to make anyone wake up at 3 a.m. in the morning. And as it is also the end of the group phase, just a short question, as there is another match shortly after. I would like to ask a group question, let's say, to the teams at the same time, starting with the team of King's College London. Would be, how did you find the group phase and the experience? And would you say, what was the skill that you've learned or improved on, or the experience that you've had that stands out the most?
I can take that. Yeah, the group phase has been great. I think every round has been so different in that we've gotten feedback and then realized, oh, we need to focus on this now, and then we need to improve this and that. And also in just terms of the breadth of content, I think they are definitely niche areas. Well, I wouldn't say niche, but they're definitely areas of law that we haven't encountered in our degrees. And so it's been so fascinating learning about this. And I think having the sort of 1 week preparation time and then being like, okay, how do you understand a whole area of law? Obviously not like top to bottom, but like enough that you can make cohesive arguments and then also make cohesive rebuttals. And I think that's definitely a valuable skill, especially when we do moot competitions and things like that. It follows a similar structure, as in you have the same amount of time to prepare, and then you have to present your case. And I think that's definitely a valuable skill to have for any future lawyer. So yeah.
Thank you for sharing. Perhaps Ms. Nematzadeh, if there's anything you wish to add.
I mean, yeah, I definitely second everything my debate partner said, and I think that something this debate competition especially taught me was how to structure your, or I guess you could say how you can kind of get bogged down in your own line of thinking, especially working with my debate partner throughout this entire competition. Something that we would often do is we would often debate each other, not purposefully, but we would just have different approaches to the question. But that in and of itself ended up just adding to our points of argument, and we realized how complex what we thought was a simple approach to a debate question could be. So I definitely enjoyed the team aspect of this, and the questions. The questions were very, very eye-opening, especially in the research, because like I said, you could take the question and the research, but then apply it into other areas of international law. So I really, really appreciated the research that these questions required.
Thank you for sharing. And actually, the same question to University of Antioquia's debaters would be, as it's the end of the group phase, how did you find the experience? And perhaps what is the skill that you've gained or improved on, or experience you've had that stands out to you?
Firstly, I want to thank the judge for the tips he gave us. Like, it was very helpful, not only for the debate, but for our life in general. And for the experience, it was quite interesting. Like, for me, and I believe for the our entire team, the biggest challenge was the English language, as it is not our first language. However, that's precisely what we have learned the most from getting to know our opponents. That has also been a rewarding experience, as well as connecting with other parts of the world. So yeah, I think that's like the most I want to say.
Thank you. Ms. Barbosa, Ms. Vasquez?
Me. I think that the work as a team was the best experience that I'm taking from this competition, because it's really hard to share like the same time and the same spaces with all the participants, and also improve and react like in moments that are unexpected, and of course like all the knowledge that I acquired.
Thank you for sharing. Ms. Vasquez, if there's anything you also wish to share?
Yes. First, I feel so grateful with you and with the judges that he gave us his feedback. And also, I agree with my colleagues. I think that the language was a challenge because it's some different, but also it's like a huge difference with the English of, or more like legal English. So it was so interesting for us. Also, for me, this experience to try to define argumentative structures and also to be a team was and is a great experience to meet new arguments, to meet new cultures, and have this type of relationship is something that I feel so grateful for that. And sitting down and trying to give solutions to legal issues, legal problems, it's also refreshing for me. So thank you for that.
Thank you. Thank you for sharing. Thank you, everyone. And I just want to congratulate you all for your debates, not just this one, for all of them. And as you have improved and presented yourselves and grown with each round and each argument that you have presented in the competition, it's been a pleasure. I wish you all the best for the next matches and for all the endeavors you do. We now have a little break in the competition to relax over the Easter break. And of course, after the Easter ends, there will be the mid-edition event. I really encourage you to have at least one member join in, as it will be also a possibility to meet other students from the teams right now that you are meeting, but also from the previous matches and other groups. So on that note, I wish you all the best and have a great week ahead. Thank you. Goodbye.
Bye-bye.